In this video, we will be looking at co-ownership and strata within property law. So some of the topics that I will be covering, first of all, I'll be talking about joint tenancy, and then I'll be discussing tenancy in common, and then finally, what a strata scheme is. Now, the first two, these are types of ownership that exist in law. So starting with joint tenancy, this is where each tenant would be classified as owning the entire interest in a particular piece of land. So let's just assume that there was a piece of land and there were two parties that owned that land, and the ownership type was classified as joint tenancy. The interest, the entire interest of that land would belong to each of the tenants. So each tenant would have that entire interest. So it's not split in a percentage. The entire interest belongs to each of the tenants. Now, one point to note is that when we mention the word tenant, we're referring to owner. So legally in property law, when we say tenant, then in this instance, we're referring to the owner. The thing about joint tenancy is that there is this right of survivorship. So that what that basically means is that if you had two parties under a joint tenancy owning a piece of land, if one of the parties dies, then the other takes it all. And it's specified in the Conveyancing Act 1919, Section 25 and Section 35. Common law usually presumes that there is this formation of a joint tenancy wherever possible. It's mostly based on express words. So if it can be established that it was expressly agreed by the two parties involved that it would be a joint tenancy type of ownership, then the common law is very likely to presume that this formation of joint tenancy actually occurred. In terms of severance of the joint tenancy, it can happen via several means. So it can be through a court order, it can be by a mutual agreement of the parties, and it can also be a result of a unilateral action of one of the parties. Now, in order to have a joint tenancy, there's these legal elements that have to be satisfied. So 4 legal elements that need to be satisfied. The first legal element is the unity of possession. That's where each tenant has the right to enjoy possession of the entire interest. The unity of interest, second legal element, is where each tenant must hold the same interest in the property at the same time. So both tenants, both owners have to have the same type of interest. So you can't have one tenant with a fee simple interest and another with a life estate. They both have to be of the same interest type. The third legal element is unity of title, and that's where each tenant must hold the title of the same property through the same instrument. Now, the word instrument over here can be taken to mean deed. So a deed can be the instrument or a will, for example. And then the final legal element is the unity of time, and that's where each tenant must have received their proprietary interest at the same time. Otherwise, this other ownership classification would be assumed, and that other ownership classification is a tenancy in common. So what is a tenancy in common? A tenancy in common is where this time each of the owners would own a share of the property. So let's say that you had two owners for a particular piece of land. Party A, so the first owner, would own 70%, let's say for example, and then party B would own the remainder, which is 30%. Now there's no right of survivorship. That's what differentiates tenancy in common from a joint tenancy. If the legal elements of a joint tenancy are absent, then automatically the common law will find that there is a tenancy in common. So you have a particular type of ownership and you're assuming it's a joint tenancy. You look at the legal elements that we went through. If these legal elements are absent, then the type of ownership is classified as a tenancy in common rather than a joint tenancy. Now, when would the tenancy in common arise? It's most likely to happen when you have owners contributing different amounts or when you've got a business partnership involved. Now, the statute that's involved the statute that's of concern is the Conveyancing Act, and it assumes that a tenancy in common rather than a joint tenancy uh, is sort of what exists unless there is evidence to the contrary. So if both parties had expressly, as I said, agreed that it would be a joint tenancy and there was evidence for that, then statute wouldn't, in this case, assume it's a tenancy in common. But otherwise, the general assumption is that a tenancy in common is what exists. Now, note that this is a bit different to the common law, where common law tends to favor joint tenancy. But when we're talking about, the statutes versus common law, statutes usually dominate the common law. And this particular point had been raised in this case that's highlighted in front of you on the screen. If one of the owners acquires all of the share, so if we had the two parties that were involved, the same example, party A and party B, if party A acquires the interest of party B, then the tenancy in common would be severed in this case. Okay, so now we're talking about right to possession. So a co-owner has no right to claim an occupation rent against another co-owner. So when you've got this joint tenancy or a tenancy in common, so this sort of co-ownership that's taking place, one of the co-owners cannot claim an occupation rent against the other co-owner. However, there are exceptions. So this is not permissible unless there's an agreement to pay an occupation rent. So both parties agree that there's this, this rent that has to be paid from one party to another, or if it's found that one of the co-owners ousted the other, and this was highlighted in this Queensland case on the screens in front of you. If the co-owners had been in a domestic relationship, but it was no longer viable or reasonable for them to live in the same premises, then maybe an occupation rent can be claimed by one of the owners. The person, so in this case, in the case of the relationship, the person that left that relationship, so the person that stays in the property might need to pay rent for that person that left. Or if the occupying co-owner is claiming compensation in terms of the occupation rent that they're collecting for the improvements that they made to the property against a non-occupying co-owner. So there's a co-owner that doesn't live in the property, and a co-owner that lives in the property improved, sort of refurbished the house or the unit that they live in. So in this case, to claim compensation for the money that they spent in terms of refurbishment, they can claim that occupation rent. Okay, so now we're moving on to the final topic in this video, and that's strata title. It's a statutory co-ownership. It was introduced in New South Wales in 1961. The reason that it was introduced because there was this is when high-rise buildings started to boom. The relevant statutes are the Strata Schemes Development Act, so SSDA, and Strata Schemes Management Act, SSMA. What a strata title does is that it allows the ownership of discrete portions of a land. So you have a land, and this land gets divided into lots. So people usually would own the lots, and then you'd have common property, and that common property would be vested in an owner's corporation. So what is an owner's corporation? It's comprised of all the owners of the lots in the strata scheme. And these owners can assign a strata managing agent to act on their behalf. So in this case, the decision of the strata managing agent is taken to be the decision of the owner's corporation. Now, a lot of disputes are typical to arise in such a scheme. So there has to be means of dealing with these disputes. These disputes are dealt with by the Consumer and Commercial Division of the New South Wales Civil and Administrative Tribunal, NCAT. Mediation is usually the first step that would be recommended. in the case that a dispute arises between, the owners. If that dispute cannot be resolved, then NCAT has the power to make certain orders. Now, appeals can be made to the Supreme Court of New South Wales, where civil penalties are imposed by NCAT. So if you're not happy with the penalties that are imposed, then you can appeal to the Supreme Court of New South Wales. Finally, when it comes to termination of the Strata scheme, it is possible. However, it has to come from the Supreme Court. So the Supreme Court of New South Wales can order the termination. An application can also be made by a lot owner in a Strata scheme, or the owner's corporation, or the mortgagee, so the person lending money to an owner in that Strata scheme. So in this case, when the application is made, the Registrar General, which is the regulator that ensures the integrity of the New South Wales land title system, can terminate the Strata scheme. However, for this termination to happen, there has to be at least 75% of the lot owners that consent to the termination of the Strata scheme.